students, this is Jonathan Lipson with The Real Deal on Contracts. Today we're going to talk about the parole evidence rule. This corresponds to Unit 28 if you are in my class. The parole evidence rule is another one of these interpretive rules. We've talked about some of them already. They're mechanisms by which courts can engage in some social control of free contract. The general rule in the parole evidence rule is that courts may not use evidence from outside of a writing to contradict or vary that writing if the writing is a complete and final agreement. So, for example, prior oral, or written agreements, drafts, emails, all that kind of stuff. That is extrinsic evidence outside of the writing, and the kind of basic approach under the parole evidence rule is that that's not supposed to be used to vary or contradict the written contract. Having said that, the common law and the UCC recognize that, in many cases, context does matter. The real deal may be different from the paper deal, and in some respects, we want to know what that real deal was. So the parole evidence rule and its exceptions are simply ways of trying to figure that out. The common law's approach is quite complex, and we're not really going to focus on that. Instead, what we'll do is talk about UCC 2202 and its approach to the parole evidence rule in contracts involving the sales of goods. To do so, I have here a flowchart that I have made, possibly legible, and it has 5 parts. So under the UCC, the first thing that you want to ask yourself is, do we have a final agreement? A final agreement is the way that UCC 2202 talks about, a written contract signed by the parties. If the answer to that question is no, then you don't have a parole evidence issue. You might have a statute of frauds issue, of course, but you're not going to have a parole evidence problem because there is no written agreement as to which there could be extrinsic evidence. If instead the answer is yes, the next question is there extrinsic evidence? If the answer to that is no, then again, there's no parole evidence rule issue. There may be other interpretive issues involved. So for example, if you think about the Yauger case, the court was very concerned with how to interpret exculpatory provisions in a contract, but it wasn't focusing on language or behavior or what have you outside of the agreement. It was just concerned about how to interpret language and adopted an interpretive approach that we discussed there. If the answer to the extrinsic evidence question is yes, that is to say there is some stuff outside of the contract, then the third question is, does that stuff outside of the writing vary or contradict the final agreement? If the answer to that is yes, then the parole evidence rule says that language or whatever it is, content outside of the writing will be barred by the parole evidence rule. A court can't consider it, a jury can't consider it, unless that extrinsic evidence was evidence of fraud or mistake. We say, of course, extrinsic evidence of fraud has to come in because we don't want to allow fraudsters to use their parole evidence rule as a way to get away with their fraud. Fine. If it turns out that there is extrinsic evidence that does not vary or contradict the final agreement, then that extrinsic evidence will be admissible to show what I have called mnemonically PUDCAT unless if. PUDCAT unless if means the following. Courts can consider things like course of P, performance, U, usage of trade, D, course of dealing, and consistent additional terms, CAT, unless those consistent additional terms are being used against an integrated fully contract or a fully integrated contract. What that means is that you need to think about whether the contract you're looking at has something called a merger clause. A merger clause is a provision in a contract that says this is the final and full expression of the parties' agreement, and all prior agreements are merged into it, or something like that. Those provisions are pretty common, and what those mean is that you have a final and complete agreement, and so consistent additional terms can't be used to, obviously, to contradict them, but or also cannot be used to supplement or explain them. Course performance, usage of trade, course of dealing, those sorts of things can be used to supplement or explain a written agreement, even if it is a fully integrated agreement. But again, they cannot be used to vary or contradict it. Now, what's the difference between vary or contradict on the one hand and supplement or explain on the other? Well, obviously, at one level it's sort of intuitive. If the written agreement says blue and the email between the parties says not blue, right, we have a contradiction and we have a problem. If instead we see language that's more general outside, or we see, for example, a course of conduct between the parties over time that doesn't necessarily contradict something in the writing, but does tend to explain it or fill in a gap, then courts will use that, and that's considered to be acceptable. And that is the real deal on the parole evidence rule. We'll discuss this more in class shortly. Thanks.